welcome to the 92nd session of Legal Empowerment through Interaction Lecture Series. Today we have a wonderful speaker, and that too suggested by one of our wonderful speakers earlier in 2 occasions, Amit. We do welcome Swathi, Sukumar, and I hope whatever little intellect I have, I'll say that intellectual property is worth whatever it is. So before I say over to you, Swathi, I recognize the presence, and we are privileged to have Justice Ramkumar sir and all wonderful persons, participants who were there in this journey till we reached 92nd today. So directly over to you, Swathi.
Thank you so much, Shyam. Good afternoon, everyone. First of all, sorry for the loss of your colleague. Every day there's some news or the other on many misfortunes that are being caused to people. And one wonders whether there's any context for a specialized field like IP in this world. But leaving that concern aside, to introduce myself, I'm Swathi Sukumar. I have about 15 years of specialized experience in intellectual property law. My practice is based primarily out of Delhi, and sometimes I'm in Bangalore as well. Now, my topic today is the liability of intermediaries for copyright infringement and for trademark infringement. You may be familiar with the term intermediary. The word intermediary is used in a legal sense, but plainly speaking, intermediaries can refer to websites, social media platforms, and any online services that allow third persons to interact with each other. So to give you an example, YouTube is an intermediary because it allows content to be posted by some people and for other people to comment. So it involves the ability to allow people to interact with each other over its platform. Now, it is also, the legislative definition of intermediary also includes internet service providers. So even Airtel or BSNL could be considered an intermediary. Now, the word is hugely relevant while considering the liability of intermediaries for certain acts that are illegal. One category of such illegal acts is IP infringement, but there might be other cases, such as right now, you're all aware that Mr. Prashant Bhushan has been hauled up by the Supreme Court for contempt of court based on the statements that he made on Twitter. So that would also be, Twitter is an example of an intermediary. Now, I'm going to bore you with the definitions on a PowerPoint slide. I need to show you 2 important provisions. First, I need to show you the definition of the intermediary, and then I have to show you Section 79 of the Information Technology Act. The Information Technology Act is the 2000 is the code that governs the protection and the rights and the liabilities of such intermediaries. Now, I'm going to do a screen share to show you the definition first, and then I can show you the other provisions, and then I'll go on to the judgments after. Oh, can you, Mr. Premraj, could you enable screen sharing so that I can show my screen, if it's possible?
Wait, let me just see. I think you have to send a request, right?
I have.
You have sent?
Yeah.
I haven't received it.
It just says host is disabled participant screen sharing. So I think you just have to enable it in settings. Just see, if it's not possible, no problem. I'll copy and paste the provision on the chat box so you can see it.
Multiple. What should I do to screen share?
Okay, don't worry, don't stress about it. I'll just copy and paste it. Hold on.
Okay. Right now, just see if you can screen share.
Yes, thank you. I can. So you see this definition. This is the definition of an intermediary. Okay, an intermediary with respect to any particular electronic records means any person who, on behalf of another person, receives, stores, or transmits that record or provides any service with respect to that record, and includes telecom service providers, network service providers, internet service providers, web hosting service providers, search engines, online payment sites, online auction sites, online marketplaces, and cyber cafes. Now, please see how wide this definition is. And it's
an IT Act. Is it an IT Act?
Yes, sir. 21W of IT Act. Now, you have such an overarching wide definition that basically includes the whole world of commerce that we know, right? So obviously it's a definition of great consequence. And one thing we must understand about law and technology is that law is always trying to keep up with technology. And you will find even in the course of the judgments that I will show to you, that there is a gap between what the technology is capable of doing and what the law is capable of regulating, right? So we often see that there is a conflict, and often both lawmakers and courts get it wrong because they don't understand the way technology completely works. In fact, some years ago, I must share, I was in a hearing in the early stages of my career. About 15 years ago, there was a hearing on software piracy. And the court innocently asked the question, where do the software pirates come from? And the senior counsel who at that time was leading us said they come from the high seas. So they thought pirates means they will come on a ship the way, other pirates come, like Pirates of the Caribbean or whatever. Now they don't know the concept of software piracy, right? So please bear in mind throughout my presentation that some things which may seem obvious to you actually has taken the years, Supreme Court and the High Courts and the lawmakers several years to arrive at that level of understanding of technology, just because of the pace at which technology changes, right? So I've read out section 2(1)W to you, which is an overarching definition that covers many diverse sets of actors. Now in 2004, you may remember there was an unfortunate incident where 2 school children were involved in a sexual act which was captured on camera, and then that CD was sold on eBay. And you may remember that a gentleman called Avnish Bajaj, who was then the CEO of eBay, was jailed under the IT Act, right? And at that time, we didn't have a sophisticated understanding of what is an intermediary? To what extent can you hold an online marketplace liable? That issue had not been dealt with at all. So to 2004, Mr. Avnish Bajaj spent some time in jail precisely because the nature of an intermediary was not understood. Now let's go to section 79. Now section 79 explains the consequence of being an intermediary. Oops, what is this? Oh, I'll just do. Okay, now section 79(1). Okay, exemption from liability of intermediary in certain cases, notwithstanding anything contained in any law for the time being in force, but subject to the provisions of subsections 2 and 3, an intermediary shall not be liable for any third-party information, data, or communication link made available or hosted by him. Now, this is a very clear categorical opening that as a matter of rule, if I am an intermediary like Twitter, YouTube, Facebook, I am not responsible for any third-party information, data, or communication link made available or hosted by me, subject only to subsections 2 and 3. So now let's examine subsections 2 and 3. Subsection 2 says, the provisions of subsection 1 shall apply if the functioning of the intermediary is limited to providing access to a communication system over which information is made available by third parties. Second, the intermediary does not A, initiate the transmission, 2, select the receiver of the transmission, and 3, select or modify the information contained in the transmission. 3, the intermediary observes due diligence while discharging his duties under this act and also observes such other guidelines as the central government may prescribe in this behalf. Please note the words in subsection 2C, due diligence, because what does this mean is also something that has come up before court, and it is something that one will need to bear in mind while advising either a platform or somebody who is aggrieved by something on the platform. What is this requirement of due diligence under 79(2)(c)? It's a very, very important clause. Then please see section 79(3). The provisions of subsection 1 shall not apply if the intermediary has conspired or abetted or aided or induced, whether by threats or promise or otherwise, in the commission of the unlawful act. And B, upon receiving actual knowledge or upon being notified by the appropriate government or its agency that any information, data, or communication link residing in or connected to a computer resource controlled by the intermediary is being used to commit the unlawful act, the intermediary fails to expeditiously remove or disable access to that material without vitiating the evidence in any manner, for the purpose of this section, so on and so on. Therefore, again, the requirement is actual knowledge. Now, we will keep coming back to these provisions. I just wanted you to take one look at them. I'm going to stop screen share and I will walk you through why these clauses are relevant. Section 79, 1, 2, and 3 over the years have been subject to a lot of litigation. And I have to say that the courts have actually clearly understood what these provisions mean and they've told us. So this is not, many of these phrases have been clarified by the court, and today I will be walking you through those decisions that have clarified the meaning of these words, which at first look completely ambiguous. Now, my presentation today is really confined to IP infringement. So let's look at what is it? How is IP infringed on the internet? Now, I'm sure I have colleagues on this in the audience who are IP lawyers and who are aware of IP. So I may be explaining something very, very simple, but just for the sake of good order, for completeness, I'm going to explain what amounts to IP infringement. Let's start with the Copyright Act. Now, under the Copyright Act, if I am the owner of a literary work, musical work, dramatic work, sound recording, or cinematograph work, I have certain exclusive rights under Section 14. Now, if you look at Section 14 of the Copyright Act, one of the exclusive rights I have is to reproduce the work. The other exclusive right I have is to communicate the work to the public. So these are the rights that are usually involved in cases of copyright infringement involving platforms. So this is as far as copyright is concerned. Now, similarly, under trademark law, you have provisions that when I use a trademark in the course of trade, or I sell an infringing good, or I offer for sale an infringing good, I would be committing infringement of trademark. And this is the context in which the platforms have also been involved in infringing IP rights. Now, let's turn first to the decision. With an excellent decision of the Division Bench of the Delhi High Court in Myspace versus Super Cassettes. Now, what happened in Myspace versus Super Cassettes was this. Super Cassettes is the owner, as many of you know, they're a big recording company, T-Series. They own sound recordings and underlying works in many, many films and, millions of sound recordings, really. So what happened was Myspace, which is not a website, which is not a platform which is very active now. Myspace was allowing users to share videos, share music, and some of those videos were infringing Super Cassettes' copyright. So somebody like YouTube was coming and posting infringing content, and the Super Cassettes' grievance against Myspace was, how are you allowing these to be posted in the first place? And you should automatically remove them. So every time Super Cassettes wrote to Myspace, Myspace would remove it. But then the volume of infringement became high, so Super Cassettes filed a case against Myspace. Now, their main grouse was that you are allowing your platform to be used for illegal activities because you are allowing your platform to be used by infringers. You are making money because you are getting advertising revenue, like all YouTube. Also, you will see there will be those advertisements. Their point was that you are profiting from the infringement. Therefore, you are not an intermediary that is entitled to the exemption under Section 79. So their point was you are actively contributing to the infringement, and therefore you do not have access to Section 79. Therefore, you have to be impleaded in the suit. Now, the single judge passed an injunction order against Myspace. Myspace filed an application for vacation of the injunction, and then in that application they said, we have millions of users. When will we start screening? How will we do it? If you tell us what is infringing, we can take it off. But how can we pre-censor any links that are put up? You give us the URL that is infringing, we will take it out. Now, the single judge found against Myspace and said that no, Myspace should, even before putting things up, should verify whether it has got proper title, whether it is infringing copyright, etc. Now, the single judge, after the single judge granted this order, Myspace filed an appeal saying that, look, how can you grant a relief like this? I have millions of users. Now, if I start reviewing each hit and each person who uploads the URL, our business will come to a standstill because there'll be no time to do anything else. So it's not practically possible. And it said that, look, I do not have actual or real knowledge. You may remember you saw the phrase actual knowledge. It says I don't actually have actual or real knowledge to be able to take off these links. For that, you have to give me knowledge. Once you give me knowledge that it's infringing, I will take it off. So that was what MySpace's case was. Now, the single judge had also held that MySpace is like a physical space, right? It's like a space that they have rented out to third parties such as the users. So in that conception, if you think of MySpace as a physical space, somebody is coming and doing something illegal in your space, it is your responsibility, like a landlord would be responsible for the actions of his tenant. So the construction of MySpace as a physical space was one of the bases on which the single judge granted an injunction against MySpace. Now MySpace filed an appeal against this order, and the division bench set aside the single judge's order. One of the first grounds on which it set aside the order was Super Cassettes has the duty to specify which are the works and identify them clearly. It is only then that MySpace is obliged to take it up. Then it is only when a specific work is mentioned. So you have to tell me that I own the rights in X song and it is being infringed. So I have to identify my right as well as the infringing work, and then only MySpace is obliged to take it off. Therefore, it's only when MySpace has specific or actual knowledge, or when it has reasonable belief, that it has the obligation to take it down. Now, if you simply attribute knowledge to the intermediary industry, it will most likely lead to shutdown, especially when you're talking about millions of users. So therefore, the court held that Section 79, which in US parlance, it's called the safe harbor defense. The court held that MySpace was entitled to the Section 79 safe harbor defense, and therefore there was no liability that could affix on MySpace as a result of this act, and therefore interim relief was denied. Now please bear in mind that all the cases that we have, which are kind of definitive, they are still only at the interim stage. Now the question is whether at trial the plaintiff will be actually able to prove that MySpace had actual knowledge. That is an issue of fact which will be decided at trial. So as far as the interim relief is concerned, the court held that intermediaries cannot be held liable, and if in this manner, that is, as soon as something is up on my website, it doesn't mean I have knowledge. The minute you post illegal content on Facebook, it's not that Facebook will immediately have knowledge. You have to prove knowledge, you have to plead knowledge, and in the case of copyright infringement, you have to be specific about which is the infringing recording, infringing work that you are aggrieved with. Now, this was also followed in the case of design infringement, in the case of Kent versus eBay. Now, what happened in Kent was that there were a whole bunch of products of Kent which were available illegally on eBay, and some which were the infringers' products were available on eBay, which had the Kent registered design on them. Now, the court held, the single judge of the High Court held that, look, eBay cannot be an adjudicatory authority, that every time somebody posts it, it will decide whether it violates the infringement, it violates the design right. So therefore, you do not have to immediately automatically take off infringing content unless, again, you have real or actual knowledge. So everything boils down to having real or actual knowledge. In both cases, in Kent, single judge, MySpace division bench, there is a requirement of knowledge which has been imposed. Now,
Swathi, before you say, could you just give the citations when you cite the case?
Sure. Can I just come back to it? Because you know what I've done is in my notes, just hold on, I'll just give it to you as and when we.
But are interim orders published?
Yes, sir, they are. So can I just paste it in the chat?
Yeah, or else even if you say the participants, they will load it down.
I've just put it there. Sorry.
MySpace, I think already somebody has put it.
No, don't worry about it.
2017-236 GLG 478. Yeah.
So these are the two judgments. So both MySpace and Super Cassettes had a uniform standard that intermediaries cannot be held to be liable automatically as soon as there's infringing content. So the next, so then the next question that arises in the provisions that I showed you is due diligence. Now let's look at due diligence. Where does due diligence find a place? The intermediary observes due diligence, right? So this phrase, so the Government of India issued Information Technology Guidelines of 2011 to prescribe what are the due diligence requirements that an intermediary has to follow to be entitled to the exemption under 79(1). Now it was threefold. First is that the intermediary shall inform the user of the computer resource not to host any information that infringes any patent, trademark, copyright or other proprietary rights. So you would basically need to have one of those terms and conditions of use which you click on, in which you take an undertaking from the user that they will not violate copyright, trademark, patent or any other intellectual property rights. Second is you will not knowingly host such information. The third is the intermediary either upon knowing by itself or when an affected person brings to its actual knowledge shall act within 36 hours to disable such information. Now this question of actual knowledge is a very vexed question, right? Because is it enough if I write, suppose something is on YouTube and I am a third person and I say that this violates A.R. Rahman's rights. Does YouTube have to take it down? There seems to be 2 or 3 different answers, because according to the intermediary guidelines, suppose I'm an affected person, they have to listen to me and take it down, huh? Because that's what the intermediary guidelines say, that the minute it comes to your actual knowledge, okay, I have told the owner of YouTube, I have told the administrator, this violates A.R. Rahman's copyright. The question is, does the website intermediary or the online service provider have an immediate obligation to take down the content? Now, the Supreme Court had the opportunity to answer this question in Sri.Shyam versus Union of India. You may know of the decision. It's a very famous decision for having struck down Section 66A of the Information Technology Act. But Sri.Shyam also dealt with Section 79, where the court held that, look, actual knowledge doesn't mean you are told by somebody. It means then there is a court order. And this is a very, very important departure, because till Sri.Shyam, courts were saying, including Myspace, that unless Super Cassettes writes, then there is no actual knowledge. But Supreme Court lifts the bar and says, no, it's not the affected person, it's not any person. A court order has to be issued that this information is illegal, right? Or the information needs to be taken down. Because if you don't do that, what's going to happen is that you're going to have 2 people who are both saying, no, it's illegal, no, it's illegal, no, it's mine, no, it's not yours. And then the intermediary has to be an adjudicating authority, which it cannot do. Therefore, today, the legal position after Sri.Shyam is that if there is a conflict of rights, it is not enough for the proprietor or the owner of copyright to simply file a complaint and expect that it will be taken down. So the Supreme Court in Sri.Shyam observed that actual knowledge means having actual knowledge through a court of law, through a court order, right? So this is a very, very important departure. So it read down Section 79(3)(b). Let me just again take you to 79(3)(b). Upon receiving actual knowledge. So upon receiving actual knowledge has been read virtually as upon receiving a court order, right? Not anything else. So that is the standard. So it has, Sri.Shyam made life much easier for internet service providers. Given just the volume of internet transactions, it will become difficult for an internet service provider or for a social media platform to become an arbitrator. That's not their job. And if you are aggrieved, then you file a case and you will get relief. So that was the, that was the sum and substance of what Sri.Shyam said. Now let's look at the very, very interesting recent decision of Amway versus Amazon. Now, I don't know how many of you are familiar with Amway's way of operation. They do something called direct selling. Okay, so they use something called the direct selling business model, which means what? Amway will only sell through Amway authorized agents. You remember, there'll be people in in a small town, there'll be 10 families. They will contact the, one person from each family and make them Amway authorized agents. Now their problem was Amazon was making all Amway products available for sale on Amazon, right? And some instances they were repackaging the products, putting them in boxes and selling them. So the question was, is Amazon's action amount to trademark infringement? Now, Amway claimed that it received complaints from direct sellers that Amway products were being sold on various e-commerce platforms. Amway brought a suit for injunction, saying that you are violating the direct selling guidelines which the government has issued, which allows me to operate like this through direct agents. You are violating those guidelines, and you are not entitled to protection under Section 79. Now, Amazon said, no, there's no question. We are entitled to the protection of Section 79 because we don't have, I'm going to go back to Section 79 2B. They said, Amazon said the intermediary does not initiate the transmission, we don't select the receiver of the transmission, and we don't select or modify the information contained in the transmission, right? So they said the provisions of subsection shall apply if we are covered by 2B, and I am saying I'm covered by 2B. So that was what Amazon had said before the single judge. Now, what did the single judge do? The single judge held that Amazon was liable, right? Not just Amazon, Snapdeal, a whole bunch of online marketplaces, saying you are all liable because you are not passive, right? You have a very active role because not only are you you're not a passive marketplace, you have other services, like Amazon has Amazon Prime, has Amazon value-added services. You are offering something plus the marketplace. So therefore, you are not covered by Section 79. You are not entitled. In fact, it's a nice rhyme. She says you are not passive, you are massive. Massive facilitators of infringement. Okay, so she held that you are in your custody, you have all these infringing products. You are handling the logistical support of packaging them, couriering them. Therefore, you are liable. And you have also tampered the repackaging goods because, according to Amway, the product will lose warranty if it doesn't come through the authorized channel. So she's saying you've also deprived the users of warranty, right? And then she said the direct selling guidelines are binding on you, and therefore you do not have access to the provision of Section 79 giving you exemption. Now the division bench set this aside, saying that, look, whether or not the user gets warranty is really not our concern, and the rights of the user, the rights of Amway after they have sold it the first time is extinguished. I'll come back to this in defenses. So the rights of the Amway has been exhausted. No, they have sold the product. Somebody has bought it and putting it up online. How can you prevent that third person who has already paid valuable consideration? Second is that there is no distinction. The division bench held that there is no distinction between passive and active. In Section 79, it's not passive and active. I just have to show that I comply with the Section 79 subsection 2. And therefore, under Section 79(2), they found that Amazon had complied, at least prima facie. Again, please bear in mind, this is the interim judgment. The matter has to go to trial whether the intermediary had knowledge. But prima facie, the court held the fact that Amazon has complied and was able to prima facie satisfy it, that Section 79(2) conditions had been fulfilled, meant that they were automatically entitled to Section 79(1) protection. And therefore, the court held that because there are so many disputed questions of fact, from the pleadings of the suit, it is not clear whether the entity could be attributed, knowledge could be attributed to the entity to bring it out of the protection of Section 79. Please remember, Section 79 is a very overarching broad protection, which has very few carve-outs. So the court held that in view of the broad legislative protection available to Amazon, today I will not hold that Amazon has infringed any rights, and the matter has now proceeded to trial. So now let's look at what are the, this is basically a review of the judgments on this issue. Now let's look at what would be the standard defenses to an action like this. The common sense legal defense, the first would be the doctrine of exhaustion. Now, what is the doctrine of exhaustion? Is that when I sell something to you, my rights in that product are exhausted. My intellectual property rights in that product are exhausted unless there is a conditional sale. Suppose I sell a printer to you. Can you repackage that printer after replacing its parts and sell it in a refurbished market? The answer is yes, you can, right? Provided you are not posing as an authorized reseller, and you cannot be prevented from alienating your own goods. So exhaustion is one of the key defenses that most platforms will take. That, you know, in the case of Amazon, I'm just selling what some buyer is putting up. I don't have any further right or title to them. So this would be the most important defense. And this, the first most important defense, of course, Section 79, that I'm an intermediary and I don't even have to get into this dispute. I have to be deleted from the array of parties. And the second would be exhaustion. So these are some of the common defenses that are taken. So just to recap, and then I'll ask if there are any questions. But just to recap the ground that I've covered. One is, I took you through the definition of an intermediary, which is very wide, which covers network service providers, web hosting providers, it covers social media platforms, it covers everybody. And it's so expansive that I don't know if you remember 3 or 4 years ago, there was this movie which had that song, Why This Kolaveri? Remember there was movie 3? Now, somebody found one pirated copy of it on a website. They got blocking orders against Airtel, saying that nobody should be allowed to access that link anywhere in the country. They blocked 59 or 60 websites at an interim ex parte stage. So that is the power of blocking orders. And after that, of course, the order was modified, but the damage was done, right? Because if you can block a service provider from providing the service, because there is one movie to which the link is somewhere, you can understand the kind of power that the state holds in controlling the dissemination of information. Therefore, bright line rules are required. Now, I have to say that Shreya Singhal has made it very clear, and now there doesn't seem to be any doubt that a web hosting service does not have the obligation to remove content that is alleged to be infringing unless you have a court order. So that's a very positive development. And then I also took you through 2 judgments. One is Myspace versus Super Cassettes in the context of copyright, and Amway versus Amazon in the context of trademarks. So these are the 2 judgments that are really critical, and Kent versus Arrow. There are a host of other judgments that have been overruled, and so for obvious reasons, I'm not covering those. There were many brand owners in the time that the law was unclear, before Shreya Singhal, before Amazon versus Amway. Many trademark proprietors got orders blocking websites, claiming damages against websites. And even today, despite the fact that, in my opinion, the law is fairly clear, you can't take Twitter and YouTube and Facebook to court unless you can communicate the order and then they will be bound. But to make them directly liable for infringement of IP, in my mind, is no longer tenable. Yet, courts still issue notices, still issue summons, and then in the last minute, you will have somebody appear on behalf of Twitter and get an exemption from, being made parties to the suit, because they don't need to be made parties to the suit. So that, according to me, is the correct legal position. So I think now, if anybody has any questions, I'll be happy to answer them. But that's a summary of what the law is.
So you're finished?
Yes.
You want to move on to the interactive session?
Yes.
Well, it is a brilliant talk, a nice addressing, very insightful. So, Ramkumar sir, for your comments.
Yes, sir. These are all areas for intellectuals, not for morons like me. I don't have much exposure to this law. Anyway, excellent presentation. Excellent presentation. Yes, I pass on.
So, we will move on to the question and answer session. Amir KM. Okay, Amir. Just go. Yeah, you have to unmute yourself. Just unmute yourself, Amir. You have to unmute at your end.
Yes.
Okay.
Madam, it's a very informative session. And my question is with regard to the, first of all, you have mentioned 2 case laws. One is Myspace and other is Kent. my case is with regard to the, am I audible?
Yes, yes, yes.
My case is with, my question is with regard to the present intermediaries, in the sense nowadays we are hosting the webinars through Zoom. And if somebody is posting a URL or some other things in the chat box, whether he will get the benefit of section 79, or in otherwise the people, some of the people are running cyber cafes, or in a WhatsApp group, somebody is posting a URL. In that case, whether they will get the benefit of section 79.
So I think, my understanding is limited to IP, because I think there are different rules. For example, posting of unlawful content, right? Like if you're planning a murder on WhatsApp, on a WhatsApp group, right? The WhatsApp admin has been recently held to be liable, right? For some criminal acts, right? Whether that would apply to civil acts is what I am concerned with. Your question on cyber cafes and Zoom, both are covered under the definition of intermediaries. So provided they have followed the conditions under section 79.2, they would be automatically entitled to the exemption under section 79.1. Again, I'm not talking of section 79. I'm not talking about anything other than IP. Because for example, if you see, why did the Supreme Court issue notice to Twitter in that defamation case, in the contempt of court case against Mr. Prashant Bhushan? I don't know. Because as far as I know, the minute there's a court order, that court order can be transmitted to Twitter. There's no reason to issue show cause to Twitter, because Twitter is an intermediary, right? So I have been quite puzzled personally on why the Supreme Court has issued notice to Twitter, because that seems to be going contrary to Shreya Singhal, because Shreya Singhal says that there is no obligation to remove offending content unless there's a court order, right? So to the extent that your question pertains to intellectual property, suppose today on Zoom, I am playing you a copyright infringing song and that is recorded and put up on YouTube, right? Both YouTube and Zoom would only be liable to remove that when they are notified by a court order. So that's the, I don't know if I answered your question, but that's my understanding.
You can unmute. Amir, you have, okay.
Yes.
You have what exactly is your doubt?
Yes, it's already answered. And also in this context, what is the role of the representative suit? Suppose in a representative suit, one person has granted injunction, and in that context, how it is binding?
Could you, so in a representative suit for what?
Just against the infringement of copyright or something like that.
So the thing about IP is it's very easy, I'll tell you, because you need to just identify the works. And the person, it can't be filed as a representative suit. It has to be filed in the actual name of the copyright owner or the trademark owner, right? So representative suits, to my mind, would not succeed, because to identify the particular work, you have to seek action against that particular work to take it down. Now you will notice that in the case Facebook and Twitter, they have their own guidelines. They will remove infringing content if you file a complaint with them, telling them it's because to go get a court order. By the time you get court order, 100 people would have already paid some fraud website and would have gone and would have been victimized in the name of a infringing mark. So that would amount to impersonation, cheating, theft. There would be other criminal offenses that arise from it. So Facebook generally has community guidelines which would take down these infringing works easily. But otherwise, if you have to go the suit route, then you have to go, only the person who owns a copyright of the trademark can file such an action.
Okay, thank you.
Okay, so now we move on to Advocate Dilip.
Good evening, madam. Good evening. Am I audible?
Yes.
My question is with regard to the interpretation of the word actual knowledge given by the Shreya Singhal's case, that only when the court's order is produced, actual knowledge can be attributed to the intermediary. That's okay where there are rival claimants as to the title of the content. But in case there is no rival claimant, is it not sufficient that the right not to be infringed by the title holder be brought to the notice of the intermediary? Is it so? Then also is it necessary that the court order is essential?
So, to my mind, in the case of intellectual property, is entirely the nature of private property. Right? Today, if there is an infringement even in your real property, you have a house and somebody has made a small house inside your compound, you will only have to complain for some action to be taken. Now, yes, there is another category of person that could be hurt by intellectual property infringement is the unwary public, right? So you can have somebody, I had a client who had a website, a ticketing website, and some fraud website was offering deals, etc. And the people would pay there and would be conned because they would not get the tickets that they had paid for. Now, yes, the customers or consumers can also file a suit, but it will have to be based on the theory of harm, right? Harm to either private property or public interest. But there will have to be a court order that flows from this before the content has to be mandatorily removed. Now, please note that most websites have a notice and takedown procedure because it is required under the Digital Millennium Copyright Act in the US. They have a very detailed notice and takedown procedure. If I don't follow that notice and takedown procedures, which are mandated under US law, and most websites do function there, you are in serious trouble in the US because the United States has very, very strong copyright laws. So therefore, they have also a very, very powerful set of lobbies around the proprietors of works, right? So the Digital Millennium, thanks to the Digital Millennium Copyright Act, there's a very elaborate notice and takedown procedure that most websites will have, which can be available. So as a matter of fact, okay, when there is content which is infringing, you can directly write to the website and have it removed. But what happens is most of these litigations, you will note, have arisen from mass wrongs, right? Or what the proprietor like Super Cassettes was agreed that thousands of songs are available. When will I have the time to go through it? You only check it before you putting it up. That is not permitted.
Okay. Thank you, sir. Thank you.
Mr. Shankaraman?
Yes, good evening to all, sir. Madam?
Yes, sir.
Hello, can you hear me?
Yeah, you are audible.
Madam, just 3 days back we filed one suit against YouTube and Facebook. And Facebook advocate yesterday appeared and told you only implemented our India office. And we have our office at America. So you first implement that our head office. And what is the legal position?
So, I'm not, everybody makes a different strategy call on what is good for their case and why they should argue in a particular way. If you ask me the legal position under section 79, it's clear. It's not required for Facebook or Twitter to be a party. They are not a necessary or proper party under section, and they can be deleted under section 110. That is my opinion. That it is unnecessary whether Facebook, the servers are in America, then you will have to file a suit against Facebook America. All of these are procedural, we make these procedural arguments thinking that, okay, it will give us 1 more week now to prepare properly. So I don't know what the reasons behind making that argument are.
But the nodal officers are seeking for a order from competent court. So is it necessary? Then only it's made imperative to implement them. But my question is, we have implemented the Indian office, but now the Facebook advocate filed no. Yesterday also in the Supreme Court in Mr. Prashant Bhushan case, Mr. Puvaya advocate you add that American head office. That's what I am asking this question.
Now, there is another strategic reason to make that argument. I'm not giving, please don't take this as legal advice, completely uninformed. I'm answering instinctively to the question you asked. So please don't tomorrow say that I took that argument that you said and I lost the case. I'm just telling you.
No. Because in the Baba Ramdev case, court clearly said no need. No, you are having office here, then it is your duty to them.
Yeah,
but my question is,
the reason that people would make the argument that you sue Twitter or Facebook America is long arm jurisdiction of Indian court over a foreign company. You tell me how many times it's been successful. and whether, as a matter of law, when an Indian court exercises jurisdiction over Facebook America, what is the obligation of Facebook America to subject itself to the jurisdiction of an Indian court? It's a great
that we are better. Yes, exactly. Thank you.
It's an
That's what I asked.
that you go after Facebook Siberia, and tomorrow I'll see you enforce the case against, enforce the order against Siberia. Facebook India is subject to your law. Facebook Siberia is not. And whether Facebook Siberia, in Siberian law, they will say, na, whether a foreign court can issue such an order. So it all goes to the enforceability of such orders. But as a matter of law, let me assume it's Facebook India. As a matter of law, my opinion is Section 79 is clear. Shreya Singhal is clear. You have to decide on the merits before communicating the order.
Yes, thanks. That's what I mean.
Firstly, Mr. Shankararaman, your query, that's answered by the Supreme Court in Google India's case. That's a 2019 judgment. 2019-17 scale 282.
2019?
17, volume 17 scale 280.
Okay, sir. Frame, sir.
Okay, thank you so much.
No.
Now we have Mary. Okay,
yeah. Hi, Swathi. This is Mary from Delhi. I have a query. Like I am representing a company. They are garment manufacturers, and we have some of the renowned men's lifestyle brands. Like if you say Louis Philippe and all. So on everyday basis, what we do is we find counterfeiting links in the Facebook marketplaces. So what we do is like, we always used to notify to the Facebook saying that, see, these are the counterfeit links and we are the proprietor, we are the IP owner of this brand name or the trademark. And, we on everyday basis, hundreds, thousands, millions of counterfeiters, sellers are posting and they're selling the garments at a very lower rate of, just imagine Louis Philippe, the MRP of a shirt, the premium shirt is around 2,000 rupees, but we find the shirts are being sold at around 500. So what we did is, like in the last few years, we sent 2 legal notices to the Facebook, and Facebook always used to reply back to us saying that, no, we are intermediaries and under Section 79 of the Information Technology Act, we are not liable at all, as you mentioned. We don't have any other way out, but still today we are notifying it to Facebook and they're blocking the sellers from selling it. But this is an unending, business or trade which is happening in the Facebook marketplace. So my question is it is because it is an unending trade which is happening in the Facebook platform. Like, what would be your advice to me, like being an IP owner? What steps should I take? Should I file a kind of IP suit against the Facebook? Because what we did is, recently we also purchased a sample from our Facebook, and the seller used to come and deliver the product to our residence, and they used to take cash from us. So nowhere, we will be able to make Facebook liable, because they're, the purchase is not happening directly from the Facebook's account, or like how we buy it any other marketplace like Amazon or Myntra, wherein we pay directly. So, can you just advise me, like what step should I take in this?
So there's a legal answer and there's a practical answer. I'll give you the practical answer. The practical thing is to actually track down who owns these domains, right? Because these domains are all, it takes time to register a domain. To the extent that you can get the domain name details, it might help you find somebody to sue, right? Second is the Facebook community guidelines themselves, they would like infringing links, right? They don't always insist that you give a court order, provided that it's, straightforward counterfeit products. It may not. On the other hand, you may have a situation where somebody has bought legitimate Louis Philippe shirts and they are selling at a discount because they have bought 10,000 and they can afford to send 10 at a discount, right? So that is a much more difficult situation to deal with, and Facebook won't interfere. I've known myself, because for several clients I've written to Facebook for, products that are supposed to be sold only through authorized dealers, cosmetic products. And Facebook's answer has always been that, look, are you saying that these products are counterfeit? She said, no, I can't say that they're counterfeit. I don't know. So if you don't know whether the products are counterfeit, Facebook is not going to take a stand. So your only option would be actually to identify the domains where these are sold, right? Because they will have particular website addresses, track down the domain owners and file a suit. That would be my advice.
I would like to just share with you some of the point. When we purchased, we wanted to identify whether the garment which is being sold in the Facebook marketplace is a counterfeit or it is an original product. Through a quality analysis team, we found out that then the garment it's a counterfeit. So what we used to do is right now is like we find out who is the seller. What we do is we send a takedown notice to the Facebook and also a legal notice directly to the seller. So what do the Facebook do is, they block the seller's Facebook account. So in that case, the seller directly write it to us because we are IP owners of the brand. They ask us to, remove, please kindly unblock my Facebook account and all those things. But this is going on a daily basis. And I think in a day, we are removing around more than 1,000 counterfeiting links from the Facebook, because Facebook is not our authorized channel. It is not, we never sell our garments in Facebook. So we always sell in our like in Amazon, Myntra and all. They are like, we are the authorized sellers in Amazon and Myntra, but not on the Facebook.
So there are unique challenges, obviously, with each business. But I think what is underscoring these judgments and this provision is that whoever else is liable, it's not the online market. It's not a social media platform. It's not an intermediary that's liable for these acts. Right? You can arguably seek discovery from them, seek documents from a court. But that would be the more appropriate recourse rather than going after Facebook, right? Your recourse actually is only, think about it in the physical world, right? In the physical world, you will have people sitting in Palika Bazaar on the floor and selling things. Now, how would you have dealt with it there? You would have to go to the individual.
Yeah, we always, like, what we do is we investigate. Investigate we do market service. We purchase some of the samples, we identify it, then we complain it, and we take a criminal actions against them. Most of the time, we like 90% we conduct raids, criminal raids. Yeah.
So that would be, you seem to already, I think what you're doing is a correct thing legally and practically. It's a frustrating exercise. It's very, very frustrating for many people. But unfortunately, the person who can sort out that concern, I don't think is the marketplace. To the extent beyond their community guidelines, because they're also in a spot because they are not allowed to block content indefinitely, right? You make a complaint, they take it down. They can't block a page for more than 21 days. They'll have to reinstate it if they don't get a complaint or a court order.
Yeah. So one more thing, like, because here, like, the courts have made it very stricter to the intermediaries, wherein it was been given a responsibility to the intermediaries to to conduct a due diligence before posting any such links or before allowing any of the sellers to sell these garments on their platforms. But I don't think so, because like there are so many counterfeiting links. But what I believe is, I don't think so Facebook is doing any kind of due diligence.
No, Mary, you've misunderstood the due diligence requirement. The due diligence is not before every link. They have to check whether it's counterfeit or not. The due diligence
is the sellers. I mean to say sellers.
No. The sellers won't do. They're obviously the people who are infringing.
Yes. The sellers are selling the counterfeit goods.
As far as Facebook's due diligence is concerned, it's very simple. They just have to put it in their terms of use. That's all.
That's what I'm saying, Swathi. See, when Facebook is making a seller a vendor, okay, in their platforms. So we also found out what the terms and conditions, what are the checklists which Facebook is having. Okay, like if you see in Myntra, if I want to sell any kind of garments, I have been asked to submit a kind of trademark application or a trademark registration certificate before I become a vendor of Myntra. Okay, so I also found out the checklist which Facebook is having, but why they are not asking the owners, like whoever is a seller, to submit a kind of registration certificate, saying that they are the IP owner of that particular brand.
Because
think so they are doing any kind of, due diligence with respect to the do's and don'ts?
See, the onus of taking action against IP infringement is unfortunately on the IP owner. And the internet poses very, very unique challenges. The question is, who bears the burden of enforcing these very tight regulations on content, right? To the extent Facebook can do it, they do have these community guidelines that you can avail of. But just step back a second and think about it in any other context, right? Suppose there's content which I say is defamatory, right? And I write to Facebook telling them to take it down. You will notice that many of the posts that have been taken down by Facebook are actually restraints on freedom of speech, right? So often intermediaries are caught between the rock and a hard place. The rock is on one side, they have to make sure that there is full free flow of business and commerce. On the other side, they have to make sure they're not violating any law. It is for this reason that the court has held, especially in Myspace. If you read Myspace versus Super Cassettes, the court says that, look, you're talking about millions of transactions a day. It's actually not feasible for an intermediary to do this, right? Or even for YouTube to actually check that what they're uploading is not infringing. But if you notice on YouTube, if I search for the most recent movie online, it will start showing me removed links, right? This has been removed with respect to a complaint under the Digital Millennium Copyright Act. You look in Google, look for pirated latest movies and just see what the results are. So everybody tries to do their bit. The question is, whose responsibility is it to make sure that one's IP is not infringed? I think it is the primary responsibility of the owner. But yes, I think that there is a door open for you to seek recovery or other interventions from court for Facebook to release some data to you. So maybe one of the legal actions that you should be thinking of is filing a suit, but also asking for information from Facebook through a court order to disclose some things.
Yeah, that is the reason. Yeah, you're very correctly, you're talking. Swathi, what we received in our reply to the legal notice saying that Facebook is saying, only if the court allows us, if you get a court order, then only we'll be sharing with you all those informations about the sellers and all. So I think the next step is only to sue Facebook so that we can get some kind of, orders against them. Thank you so much. Thank you so much, Swathi.
Now we have Raj with a question. Raj.
Hi, good evening. Can you hear me, ma'am?
Yes.
Yeah. So just wanted your view on two things. Firstly, thank you for the session. And second, I wanted to check as an intermediary, there is an exemption which you have said, like for example in the Act. So it says the intermediary does not initiate the transmission, select the receiver of transmission, and select or modify the information. So, so when I do a search on Google, there may be say I search for an apple, there will be 1 million results in the search engine. So yes. Google select the out of the 1 million, it selects a particular few and then sends them to me. So isn't that considered to be selection? I just want your view on that, one. And modification, because we had discussed this somewhere. So when the image size changes from a full screen to a mobile to an Android to iPhone, iPad, it does change to some extent. So the image does get modified. So one is, what is your view on this? And the second question, ma'am, is are torrent sites considered to be would be covered under this shield of 79A? Because do they get the same this as Twitter or something, mainly because of the section?
Very interesting question. So let me answer your first question. The first question you asked me was whether the intermediary, somebody like Google, the selection or modification of information would fall under section 79.2 or not. Now, my understanding is that it would not, because section 79.2 says if provided that the intermediary does not initiate the transmission, select the receiver of the transmission, select or modify the information contained in the transmission. And I think this is tied to it's a personal thing. So if I type on Google, right, infringing information, or, if I type looking for an infringing product, the question is that tailored or targeted towards my query, right? So it's not general selection or modification. My sense is this would be individual selection or modification, because if you see, even in the case of Amazon, right? When I type in, you know, I want 3 books, right? I'm obviously typing what I want and it's giving me a particular selection of information, right? But that is not what section 79.2 is talking about. Section 79.2 is talking about selection or modification of the information contained in the transmission. So is it tailored, right? Or targeted towards the infringing product or towards the unlawful activity?
Yes, ma'am. But the thing is, like, for example, if you do a search, like if you search for an air ticket and then you go and you search, Google does target you, because that is now in the US, it's being considered. They even listen, whatever. So isn't it a kind of targeting, because they already know what you're looking for and then they target you? Because why I'm asking you this is because we had a cyber discussion in which the same thing was going on. So in a way, is there a lacuna I wanted to check? And see, if there is 1 million searches, they do select you as a receiver, because they will show you only those reasons which are pertinent to you, isn't it? Like if I stay in Mumbai and they're doing something, they will select that. They will not show me something in Kerala. So I'm saying, is there that you got my question? No, is there something in which they can be made liable? Like, for example, one.
The thing is that,
and secondly, that.
Go ahead.
No, sorry, ma'am. Please.
Go ahead, please.
No, secondly, because the moment you search, even if you are searching for something else on Google, and then you go and do something like, for example, a toothbrush, if you search, you have targeted ads which are sent to you immediately from Google. So isn't that selection, and can't it cover under this particular clause, for example? And modification, ma'am, technically when they modify, like for example, now I am on an Android and my screen is in front, for example. So the screen sizes of both are separate, no? The resolution, I mean to say. So isn't it enough to make them liable in that case?
So, you know, I feel that section 79.2, you're right, could be much more happily worded. But my understanding is that, like you rightly point out, all search results are tailored to you because they use cookies, right, on your desktop. So everything you search for, in fact, you will notice that if you search for something on Google, relevant Facebook ads will pop up when you're on your Facebook profile. So yes, there is selection of transmission of some information that is personal to me, right? But the question is, are they involved in the selection of transmission of unlawful information versus lawful information? You understand what I mean? Is the selection or modification has to be read in conjunction with the purpose which is aggrieved you to the information. You understand? I don't know if I'm making myself clear. But
no, sort of, yeah. Okay.
So what I'm saying is that the purpose of selection and transmission has to be a purpose which is an unlawful purpose for you to fall outside of the protection, outside of the clause of section 79, right? Because section 79 just uses selection and modification, and in the purest form, if you take the argument that any selection, any transmission, any modification would take you outside the protection of section 79, there would not be one intermediary, right? That would be exempt. Because if you look at it, for example, if I'm a cyber cafe owner, I will decide who comes into the cyber cafe and uses the computer. So then I've selected the person, correct? Second is, suppose I have a firewall in my network, in my office network, and then I am selecting what websites you can visit by virtue of the fact that I have excluded some websites. So to give the words selection, modification, transmission the meaning that would give effect to section 79, I think the only way to construe it is to say that this selection or transmission should not be with the unlawful purpose which is complained of. Right? So it's in the context of a complaint, it's in the context of section 79.1 that 79.2 is introduced, because if we take any other meaning, the worry is that it would become completely redundant, because then not even one person would be able to say that they don't select. Who doesn't select? That will be the question.
Okay. Thank you. And the second question, ma'am, regarding the torrent one.
Yeah, so torrent is a very interesting issue, because I don't know if you remember, there was a website called Napster, right? Many of you may remember Napster. So the question on Napster was, is there a substantial non-infringing use of Napster? The test of substantial non-infringing use is very relevant to the US context, because what was Napster doing? Napster was a file sharing website, right?
Correct.
So in India, we don't have that concept of we have not yet come up with a decision on substantial non-infringing use, because the purpose of a torrent site is really to share information unlawfully, right? Or to put up pirated websites and to allow downloads. So in this context, is there a substantial non-infringing use? That is a test that Indian courts have not dealt with. So yes, it's a gray area.
No, I'm saying, ma'am, has any case made any torrent site in India responsible so far in terms of this? No, it's only not for piracy, ma'am. You can download anything not related to piracy. So is there any case you are aware of, ma'am, in which any torrent site has been?
I think there was some, in the context of defamation and obscenity, there were some cases where blocking orders were sought on certain torrent sites which had certain films. Okay, so I think blocking orders have been traditionally sought on lots of torrent sites. In fact, in this 10 sports, whenever there's a sporting event, live sporting event, then usually there are these suits that have been filed just before the World Cup, right? Because what happens is that World Cup is only available on certain channels. Now, if I don't subscribe to those channels or I don't have the paid website, I can't watch World Cup live, right? So then what was happening is there were a huge bunch of websites that are websites established only to show the unauthorized, unlicensed version of that live sporting event. And usually plaintiffs get a blocking order against all of them. So I think you will find this in the 10 sporting entertainment. I'll give you the citation.
There is one for 10 sports. Yes, ma'am. I think 10 sports. Okay.
Yeah, so I think it's 10 sports. So if you see in the context of live sporting events, there's been a lot of blocking orders that have been passed. That if I know that my sporting event is going to be featured on a fly-by-night website, that website's purpose is only to show World Cup, right? Then in those cases, courts have granted blocking orders against those, saying that the primary purpose of it is actually to infringe rights. It's not a bona fide intermediary. But I don't think that any of those websites have even ever appeared before courts, right? So it's been like a blocking website, and a lot of those websites are hosted outside the country, right? Then there are geo-blocking orders that they will not be shown, they will not be available in this country, and those are then enforced by the Department of Telecommunications.
Thank you so much, ma'am.
Okay. Now, before we go to Siddhant Gupta, let me just introduce to you, Swathi. We have Justice Ramakrishnan here. Sorry, sir, I didn't see you actually.
Oh, it's all right. I'm enjoying it. I am enjoying it.
So, your comments, sir.
No, I have not heard the earlier part of this because I'm having sitting and I came and joined only by 4:30. By that time, I think your introduction period, introduction making the subject is over. And being a new man to technology itself, because I think that if you want to specialize or do something on that, you are not only specialized on what you call the law aspect, interpretation of law alone, but I think you must be technically qualified to know what are all the possible way in which it is likely to be infringed. So it is a both what you call legal as well as technology is involved. So it is we are in the, I can say that we are in the gray areas now as to how this can be blocked, etc. Because being a big domain, I think some experiments will have to be done by the courts also in this regard. It is a new area where we cannot say any this thing, but the way in which you are answering the questions, it is new information to us. Thank you very much. You are doing it in a good way.
Thank you.
Maybe it may be helpful to persons who are dealing with those area, playing, I can say play in that area in the profession.
Rameshwar sir, I can just put in this manner. Forget about the new technology, everything. Had you been an editor of a news magazine?
No.
Had you been somebody who is in charge of a newspaper, Swathi?
No.
I don't think there would have been much of a difference except for the technological interference. Your take on that?
So
not only that, I think that it's an area where, just like in the case of a press act, because a lot of regulations are there, because who is responsible is also mentioned there. But here the difficulty is the main owner. I can say that the domain owner will be somewhere else. he will be registering his office or his work in a particular place which governing that law. Probably that may not be applicable here. Some things are permissible, something is not permissible, also, not permissible here. But in such cases, there is a conflict of international law also sometimes arises. We do not know. And also, there must be some regulation according to me, I feel, even in respect of intermediaries, selection of intermediaries, when the main owner makes some attempt to permit somebody to use their platform, there must be some regulation must be there to monitor those people also. Then, because vicarious, I can even say that vicarious liability must go to them. Even in a case where in a newspaper, the local, the correspondent does something, there is a vicarious liability on the editor. Because he is expected to verify all those things, the truthness of the matter, and then only he can publish it. But here, nobody is there to manage it. So that is the reason why probably I think that there is a misuse of the public domain or space domain. I can say it is a space for domain that is being misused by several people, because you do not know which website is even a regular one or which is an authorized one also sometimes. Normal people may not be knowing it, the person using it also, or we do not know whether they are hacking and doing it also. That information is being hacked and thereafter that is being misused by them. We do not know. What is the mechanism that is provided for those things also is a matter to be known for people.
I think if I can just respond to sir, today with the internet, it's not today actually, it's about 15, 20 years old, and frankly, I'm an IP lawyer, but I'm quite behind the curve sometimes on technology, because one doesn't really fully comprehend the effects of it. It's opened up a new space. Apart from opening up a new space, it's opened up new forms of speech that we're not used to, right? Because forget in the context of civil rights, but if you look at Twitter and you see the number of fake Twitter handles that are created, number of fake Facebook profiles that are created just to spread hate, right? Just to spread false information. These are all specific, peculiar creatures that don't necessarily have equivalents in our physical world, right? We have a certain framework by which we understand the physical world. That framework may not apply in the same way to the digital electronic media, right? Whether it's email, even today, the fact that we're even having this conversation on a platform like Zoom, it's a very, very, it's a very different world that the technology opens us up to. So I'm not sure if the same kind of heavy-handed penal legislation or, the talk in terms of civil suits and civil action, whether it's really a good way to control the digital world, and whether there is a more democratic way of doing it, of maybe setting up some other kind of body that is looking at complaints that arise out of digital transactions, arise out of digital interactions, in a way where there is both free speech, but also that there's no abuse of your rights to exercise free speech.
No, I think that matter is how far you can restrain the social media is pending before the Supreme Court. It appears whether any regulation is required, how this will not be monitored, etc. I think that some guidelines may expect from in that case.
Maybe,
sometimes.
yes.
But sir,
we had Sunita saying about absolute freedom to be given, and absolute freedom to being given, I think, is with due respect to everybody, is absurd.
No, because I think what Ramakrishnan sir said, that has been already settled in Shreya Singhal first. See, Shreya Singhal goes on to say that what is the distinction between a publication on the internet and a publication in the print media. It goes on to say it is settled, because reference was also made to that 1995 decision of the Supreme Court in Information and Broadcasting Ministry versus Cricket Association of Bengal. So that's already settled, and I think Swathi, you may be knowing of the judgment in Gambhir Singh Dekre's case, 2013. Have you taken note of the decision?
No.
Because this has been settled by the Supreme Court. Because the other thing,
what has been settled? Sorry.
Regarding what is the distinction between publication on the internet and publication in the print media. It is
that's in the context of the Press and Registration of Books Act, no?
Correct.
Not IT Act. Okay. Yeah.
Correct. That is already settled. That is why that is why section 79 also stands amended with effect from 2009, right?
Right.
Right. 2009 it was different. So that is settled. And now we have one more person with a question, that is Siddhant Gupta. Siddhant, please. Siddhant, are you there?
Prem, if it's posted, you can just read it out.
No, he has not posted anything.
Fine.
He has not posted.
Swathi, I just like to say that, I mean, privacy and what do you call, like, I mean, those issues which are very dear and near to us is very good. But when it comes to you being the victim, would you subscribe to the same theory?
There's no, I'm talking only in the context of civil rights and civil wrongs. Obviously, there's a whole field of criminal law. Today, Instagram, there are police complaints filed against that boys' locker room case precisely for actions over intermediaries, right? So I'm not at all talking about criminal offenses and where there are, the personal rights of people involved. But I think,
Swathi, can I just take it from you that unless and until the person in between, the intermediary or the what do you call, whatever the terminology that can be used, has taken due care, caution, and attention.
Yes.
And had taken all, foreseeable, what do you call, ways and means of not disseminating of whatever is objectionable. And once objected, immediately takes it out. Are they off?
So first of all, just to go back, it's not all possible. Care and reasonable precaution is not the standard. The standard is due diligence. And what is due diligence? The government has already issued by a notification that due diligence means I have to put in my terms and conditions that you will not post anything against the integrity of India. You will not share obscene material. You will not share anything related to any terrorist activity. My obligation as an intermediary ends when I have taken the due diligence steps. The obligation again comes alive when there is a complaint. But just because there is a complaint, I don't have to take it down in the context, especially of IP, unless there is a court order. So that is as far as IP is concerned, the due diligence requirement is prescribed both under 2011 rules as well as an amendment to section 52(1)(c) of the Copyright Act. There was a proviso added. Apart from these two, when I've taken the steps that the intermediary guidelines of 2011 tell me to take, I have satisfied. I have tick box due diligence. Now, next, when a complaint is filed, I have to take it down. And most people, because of the Digital Millennium Copyright Act, most websites have that 21-day takedown policy where they will take it down. And within 21 days, if you don't furnish a court order, they will reinstate it. But they are not obliged to take it down in the first place if it's a complaint of IP infringement, unless there's a court order.
Ramkumar sir and Ramakrishnan sir, if you don't have any further comments, I can go to Prem.
Okay. Yeah, I am not only technologically challenged, but also IPL challenged.
Because yes, we are not, because I have not come across this act itself, because there is no occasion for us to read and other thing except dealing with section 65B as to how far the evidence can be used.
I was only listening to Swathi with great attention, that's all.
We have Siddhant Gupta. Siddhant, please go on. He asked me to unmute him, but Siddhant, are you there? I think he's not hearing because I have unmuted him. And see,
Prem, what I'll do is that let us do a summing up from you.
You can liberate now, or liberate all.
Let there be liberation. Prem.
Unless there is a hand icon.
And see, Swathi, because you were answering the question which was put to you by Shyampadman. See, you were on 79. 79, you said that it is the safe harbor model which we are adopting. If you go to the other thing, you should have the strict liability model. That is not the case here in India. We have the safe harbor model which we are following. That is why section 79 takes case of everything. Or else if it was a strict liability model, of course, just like a newspaper, anybody can.
So, we started with a strict liability model. If you see with Avnish Bajaj, 2004 is strict liability. Correct. From there, we have moved to a safe harbor model. And in fact, if you see Shreya Singhal also, the court is very conscious of the position in other countries. It says we have been informed that this is the position in other countries and therefore we are taking this kind of interpretation. So in principle, actually the bench had the option to consider the practices everywhere and consciously chose that this is the way to read down section 79(3)(b) so that it is in compliance with the Constitution.
Okay, that is what you call the notice and takedown process, right?
That's right.
And see, what's your opinion if same 79, if you place it in the broad immunity model instead of the safe harbor thing? If it's a broad immunity, what will be the repercussion?
I mean, isn't that academic? Because we don't have a broad immunity model. We have a very tailored immunity model where actually even the legislator in 2000 and then 2009 have actually imposed conditions. So we don't have a broad immunity model. If we had stopped at section 79(1), no, it would have been a broad immunity model. The minute we put in 79(2) and more particularly 79(3), you have made a conscious choice that it's not broad immunity. 79(1), in fact, if you read 79(1), it says subject to 2 and 3. Why should it be subject to 2 and 3? Take out that, then it's broad immunity. So I think we were conscious. To my mind, it seems we were conscious.
What you said is correct. So
absolutely correct.
Siddhant has just messaged me that he is unable to mute from his side, and his question is this: the Delhi High Court carved out an exception to the ruling of the Supreme Court in Shreya Singhal case, wherein the Supreme Court had held that a platform is deemed to have actual knowledge about the illegality of any content posted on such platform only when such information is communicated to the platform by way of a court order. Will a denial of this method by the intermediary amount to a rejection of an equivalent court order?
I'm sorry, I'm not following the question. Do you, can you?
The Delhi High Court has carved out an exception to the ruling of the Supreme Court in Shreya Singhal case, where the Supreme Court held that a platform is deemed to have actual knowledge about the illegality of the content hosted on such a platform only when the information is communicated to the platform by means of a court order. Will a denial of this method by the intermediary amount to a rejection of an equivalent court order?
No. The requirement of a court order was imposed by the Supreme Court. Where is the question of the Delhi High Court carving out an exception?
Correct.
79(3) was read down to be constitutional by saying it has to be a court order. The court order phrase is used in section 79(3) only by Shreya Singhal, not by Delhi High Court. Delhi High Court has not done anything contrary to Supreme Court. In fact, somebody has helpfully posted the link to Shreya Singhal. I can even find the relevant paragraph for you. But the court order requirement was imposed by Shreya Singhal, not by Myspace.
Correct. 2015 5 SEC page 1. Shreya Singhal was the case, and now again the Google case of 2019 also.
Yes, and see, I'm just copying and pasting for Siddhant's benefit, section 79(3). Shreya Singhal's paragraph 117.
Okay. So Shyamata, it's your take now. He also is not.
Where are you? Have you reached Cochin?
No, I